Hi folks, Rod Genders from Genders and Partners Solicitors here with you again. And today's video is about the 10 most common mistakes that I see that people have made in making their wills.
Today's video is about the common mistakes that I see in my law practice made by ordinary people in their estate planning, specifically regarding their wills. And the first major mistake is that nearly half of all adult Australians don't have a will at all. When you die without a will, it's called dying intestate. And that means that you're relying upon the government of the state where you lived to sort out your assets after you die. It doesn't just automatically go to the people that you would otherwise want it to go to. Now, each state and territory in Australia has its own system of laws and procedures for dealing with intestate estates. And those laws change from time to time and from place to place. So your assets won't necessarily go to the people that you would necessarily want them to go to. The next major problem that I see is that people don't keep their will up to date. A will is not a set and forget type of document. It's not something that you can just do once and then never think about again. When your circumstances change, birth of children, marriage, divorce, change in ownership of major assets, inheritance, all of these sorts of things are going to affect your estate plan. And if you don't keep your documents up to date, then there could be problems after you die. For example, if you've left a specific piece of property or a specific asset to a beneficiary in your will, but before you die that piece of property has been sold, then that beneficiary could miss out entirely. You need to make sure that you've kept your wishes, your testamentary wishes, properly recorded and up to date. There's another reason, a very good reason for keeping your will up to date. It used to be, a long time ago, that everyone regarded a will as the absolute last word in how somebody's assets would be dealt with after they had died. But in recent decades, governments around the world have become increasingly determined to interfere, and they have given courts certain obligations and responsibilities to inquire into deceased estates. And one of the things that a court will do when looking at whether to interfere with your wishes, they will look at how old the will is at the date of your death. If your will is more than 5 or 10 years old at the date of your death, then a court could conclude that it no longer accurately reflects your testamentary intentions on the day you died. So keeping your will up to date has the desirable feature of persuading a court that it is more likely to be what you really wanted to occur than an older document. The next most common mistake that I would see is where somebody has left a beneficiary out of a will. Now this happens all the time for all sorts of reasons. People become estranged from family members, feel that they've done wrong by them, they haven't been as dutiful or as friendly as one would like. And to a certain extent that's understandable and can be accommodated in a will, but it needs to be done very carefully. Typically, I will see this situation arising where people have tried to do their will themselves with a kit will, and they get it wrong. And as a result, those documents are typically more susceptible to a successful challenge than a professionally drawn will. You have to be very, very careful if you're going to leave disproportionate legacies to beneficiaries, where one beneficiary gets a great deal more than another, or if you're going to leave a beneficiary out altogether, somebody who might have had a legitimate expectation, a child for example, to share in your estate, and if you leave them out altogether, it needs to be done very carefully. The next most common mistake I see is where somebody will try to create a codicil where they have a will, and it might even have been a properly made will by a specialist solicitor, but they change their mind down the track, years later, and they start creating informal lists of who is to get what. Now, those lists can be useful, but they've got to be handled very carefully, because they could be interpreted as being a codicil, which could formally affect the will. But one of the problems with that is that very frequently people won't properly execute those lists, which means that as a codicil they may fail and may not have the legal effect that you would want them to have. So that sort of change in a document needs to be handled very carefully. Sometimes I see situations where the deceased person has died leaving children under the age of 18 for which they were a caregiver or guardian, and in their will they really should have nominated one or more persons who would be suitable to act as the guardian of the infant children still in need of care. Now, there are various state procedures set up to try to protect the needs and interests of infant children who are in need of care, but a testator, that's the name given to somebody who writes a will, you've missed an opportunity to say whom you would like to look after your infant children after you're gone, and it really is something that should be in the will of every parent who has young children. This is a trap that a lot of people fall into when they do the homemade wills, where they actually get beneficiaries to the wills to assign as witnesses, and that's a recipe for disaster, because that can be very easily challenged. This question of ownership of assets, I can almost hear the groans coming through my computer speakers now as I record this video, because it seems so obvious that people are going to be rolling their eyes and saying, oh, just get on with it. Of course we know this. You can only leave assets in your will that you own. Except that in fully 50% of cases that I see, people get confused about what they actually own. And before you get too carried away with the rolling of the eyes and the sighing, let me explain what I mean. A lot of people, and I mean a lot, will have assets that they own jointly with another person. Typically married couples will own their house in joint tenancy, and that means that they are both on the title. Now what that means is that if, let's just say the husband dies first, if he tries to leave his real estate to his daughter, it won't work, because that real estate was owned jointly with the wife, and it will pass by right of survivorship to the wife without ever going through his will. It won't be one of his assets in his deceased estate. Now that's a pretty obvious example, and you might think that nobody would ever get caught by misunderstanding that. But there are a number of gotchas like that, where assets might be held in a family trust or a self-managed superannuation fund, or a business, company, partnership, all sorts of legal structures that people operate all the time for very good reasons, but they just think of the assets as belonging to them when truthfully in law they might belong to another entity. This is an area where if you have a slightly more sophisticated setup and you're not just straightforward in your estate planning requirements, it is really, really important that you make sure you get professional independent advice from a specialist who understands what they're doing in this area. This next one is very similar to what I was just talking about. Financial products like superannuation and life insurance can bypass your estate. This is because you can make binding death benefit nominations that points the asset to go to a specific beneficiary or beneficiaries after you're dead, and therefore it can bypass your will. Now, if you don't understand that and you've accidentally said that an asset is to go in your will to a certain person, that person is going to miss out because it mightn't ever get to your deceased estate for your will to deal with. This is one that has cropped up. It doesn't tend to relate to professionally drawn wills, because when you have a lawyer prepare a will for you, typically they will offer to store the will for you free of charge, and I encourage everyone to take up that offer. You might think, oh well, it's a better idea for me to hang on to my own legal documents, but in a lot of cases problems can arise with that. The first problem is that people need to know where to locate the original will. Now, if you make it so easy and convenient for somebody to locate your original will, if you just store it in your desk at home, that means it's not very secure. And sadly, in certain families, in certain cases, the very people who have access to your house and your desk and your will are the ones who might choose to interfere with it after you're gone. For example, if you were leaving disproportionate legacies to members of your family and somebody felt disappointed that they had been left a lesser share than they felt they were due, well, in some cases people have been known to destroy or remove the will, and then there's trouble for everybody. So making it very convenient for someone to access your original will, there's a trade-off there in terms of the security of the document. So having the document stored by your lawyer is typically a very good idea, and that way only the right people at the right time can access the document. This last one is for a situation where you might have left a specific gift to a specific person, and that's fine as far as it goes, but what happens if there are other things in your estate outside of the specific gifts? You see, the old-fashioned way of doing a will was that people would do a sort of a stock take of everything that they owned at a point in time, and they would then marry up each item on the stock take list with a named beneficiary. So the sterling silver tea service went to Auntie Gertrude, and the cars went to Uncle Fred, and so on. But unless you keep those lists accurate and up to date, right up until the day you die, the chances are pretty high that there will be assets in your estate that aren't otherwise accounted for. And so you need to have a sort of a catch-all provision known as residue, so that there isn't additional complexities in your estate after you're gone. So those are the 10 most common mistakes that I see in my law practice, and I recommend that In order to avoid them, you get your will professionally drawn by a lawyer who specialises in estate planning.
I hope you enjoyed today's video. If you did, please leave us a comment. We'd love to hear from you. Share it with a friend and hit the like button.